In this lesson, we're continuing our discussion of performance, and specifically, we want to focus on the parole evidence rule. So in case you're wondering where we are in the big picture flow of our contracts analysis, we're still on performance and we're moving past the S to the P in Sarah Plays with Cats Every Afternoon. Of course, the P stands for parole evidence rule. So what is the parole evidence rule all about, right? Anytime a court is applying the parole evidence rule, essentially what they're doing is trying to protect the integrity of the written contract, right? If parties come to court and they present the court with a writing that they intended to be the final expression of their agreement, the courts are going to want to try to honor the terms in that contract as much as possible. That's really what the parole evidence rule is all about. It's trying to exclude the outside noise that might be surrounding a contract, a writing that the parties intended to be the final expression of their agreement. So if there were any statements, understandings, agreements, or negotiations made prior to or at the time that the contract is formed, the court is generally going to want to try to exclude as much of that as possible, really to try to honor what's inside the four corners of the contract, because the parties are presenting a writing that they intended to be the final expression of their agreement. So the court wants to honor that writing as much as possible. Really, it's all about protecting the integrity of the contract. So if you're looking at a contract law fact pattern, right, how do you issue spot the parole evidence rule? When do you know that you need to talk about the parole evidence rule? Well, anytime that you see pre-contractual understandings, statements, agreements that a party is trying to bring into court as evidence, right, you want to think about the parole evidence rule. It's important to understand here the timing too, right? So we can draw this up, little timeline here on the board. Imagine here in the middle of the timeline, we have formation of the contract. What we're talking about is statements made before formation up until the moment of formation, right? Any statements made in this time, whether those statements are written or oral, and a party's trying to bring these statements made into court, right? Statements that were not inside the contract, that were made outside of the contract, right? Extrinsic evidence that was made before or at the time of formation, right? That's when we're thinking about the parole evidence rule, right? And really what we're thinking about here is the admissibility of those statements. Is the party going to be able to bring in these statements, or is the party not going to be able to bring in these statements? Are the statements admissible or inadmissible? So what happens if the statements are made after formation, at this point in the timeline? Well, we already talked about this, right? This would be proposals for a contract modification, because the contract already exists. That's a whole separate analysis. So important to recognize here that we're not talking about the parole evidence rule if the statements made outside of the contract occurred after formation. That would be a contract modification analysis, which we already talked about when we discussed consideration. If the statements are made before formation or contemporaneously at the time of formation, right, then we can think about the parole evidence rule if a party is trying to have those statements admitted in court, right? So that's how we kind of issue spot. That's the situation we're looking for. We're looking for statements made prior to or contemporaneously with the writing, and then the party's trying to bring those statements into court. The question will be the admissibility of that evidence. Are those statements admissible or inadmissible? And how do we come to a conclusion here applying the parole evidence rule? Well, step number one, right, we want to make sure that we have a writing. If we don't have a writing, then the parole evidence rule is not at issue. So that should be the first thing that you check off your list. But really, step number one, once you identify that we have a writing and we have statements made prior to or at the time of formation, and then we have a writing and the party's trying to bring those statements into court, step one is going to be to ask, is the writing completely integrated, partially integrated, or completely unintegrated? So what is an integrated writing, right? We have two types. There's complete integration and partial integration, but what do we mean by integration? What is an integrated writing? Well, we call a writing integrated if the writing is the final expression of the party's deal, right? If the parties intended this writing to be the final expression of their deal, of their agreement, or of their bargain, right? If the parties intended this to be the final expression, intended this writing to be the final expression of their deal, we say that's an integrated writing. If they didn't, if the parties did not intend for this writing to be the final expression of their deal, we call it completely unintegrated. And if we have a completely unintegrated writing, which would look like a tentative draft, right? Draft email sent between parties before formation of the contract, then the parole evidence rule simply does not apply. The parole evidence rule only applies to integrated writings, writings that the parties intended to be the final expression of their agreement. And there's two types of integrated writings. We have completely integrated writings and partially integrated writings, right? Simply, a completed integrated writing sets forth all of the terms of the deal, and a partially integrated writing sets forth some of the terms of the deal, not all of the terms of the deal. In both cases, the parties intended the writing to be the final expression of the deal, but a completely integrated writing, the writing actually sets forth all the terms of the deal, whereas a partially integrated writing only sets forth some of the terms of the deal, right? So if we have a completely integrated writing, right, which we'll talk about how you make this distinction and termination in a minute, but just to give you the quick snapshot here, right, if you have a completely integrated writing, then any statement made prior to or contemporaneously with the writing is inadmissible unless an exception applies. And we'll talk about exceptions at the end. But the starting point rule is very easy, right? If we have a completely integrated writing, a writing that the parties intended to be the final expression of their agreement that sets forth all the terms of the agreement, then any statements made prior to or contemporaneously are inadmissible unless an exception applies. Now, if we have a partially integrated writing, right, a writing that the parties intended to be the final expression of their agreement, but that fails to set forth all of the terms of the deal, it only sets forth some of the terms of the deal, then we're going to say statements made prior to or contemporaneously with the writing are admissible to supplement the writing, but not to contradict the writing, right? So we can do a quick example here, and then we can talk about how we really make the distinction between complete integration and partial integration on a fact pattern, right? But just to give us an example to work with as we go through the rest of this, right? So let's keep it simple. Stick to our basic example here. Let's say that I offer to sell you this dry erase marker for $1 via email, right? I write you an email and I say, hey, I'll sell you my dry erase marker for $1. What do you think about this deal? Is this something you might be interested in? And you say, yeah, sure, that sounds like a good deal, but why don't you send me over your final expression of the agreement and I'll look that over, right? So you say something like that, like, yeah, maybe, let me look it over, put it in a more formal document, give me a final expression of the deal, and I'll look it over, right? So I go back and I draft up a little contract, I write this out, and then I send that to you. But now the contract says that the price of the dry erase marker is not $1, it's $5. And you look over the contract and you say, ah, you know, this looks good, I accept, you sign it, you let me know, hey, I signed it, I accept, let's do this thing, right? So then I tell you, okay, cool, pay me the $5 and I'll give you the dry erase marker. And you say, wait, I thought we said before this contract that it was $1. And I'm like, well, it clearly says in the contract that it's $5, right? So if it goes to court, can you bring in the prior email to show that the price really was $1, not $5 as the contract said? Well, the first question would be, is the writing completely integrated, partially integrated, or completely unintegrated? So did we intend for this writing to be the final expression of our agreement? Here, yeah, we did. We said, hey, look, let's make this the final expression of the agreement. Send me over a more formal document. So that's an integrated writing. Now, the initial emails that we sent back and forth, right, what would those be? Those are completely unintegrated, where we were just inviting the deal, right? We were discussing and bargaining and negotiating, but none of those emails we sent were intended to be the final expression of our deal. So those are completely unintegrated. But we did arrive to a final expression, right? That is an integrated contract. So let's say that it's partially integrated, and we'll discuss the difference between complete and partial, right? Or we could say completely integrated first, right? So if we find that that's a completely integrated contract, then all statements made prior to or contemporaneously are inadmissible, right? Unless an exception applies, but let's assume no exception applies, then we know that that prior email that shows that we originally agreed on a $1 price is inadmissible if we find that it's completely integrated. But what if we found that it was partially integrated? What would happen there? Well, the statement is admissible. Any statement made prior to or contemporaneously with the writing is admissible if it's to supplement the writing, not to contradict it. In this case, you would be bringing in that evidence to contradict the writing. You're saying, look, it wasn't $5, we agreed to $1. That's a direct contradiction. So that would be inadmissible, again, unless an exception applied. So either way, we find that's completely integrated or partially integrated. That prior agreement that we agreed on for $1 is inadmissible unless an exception applies. Now, what if it was something that wasn't included in the contract, right? Let's say that I send you over the contract and it was for $1, right? Which we agreed upon in our prior negotiations. But let's say also in our prior negotiations, we agreed that the dry erase marker was going to be black ink, right? And then let's say I, of course, deliver you, and then we sign our final expression of the contract, and it makes no mention of the color of the dry erase marker. It just says, I'm going to sell you a dry erase marker for $1 and you sign it. Right, and then let's say that I deliver you a black ink dry erase marker, even though in our pre-contract negotiation we agreed on a blue ink dry erase marker. I think I just switched that around. So let's say in our pre-contract it was a black ink marker, and then I delivered you a blue ink marker. Well, could you bring in evidence of our prior email exchange to show, hey, look, the marker was supposed to be black ink, he delivered me blue ink? Well, in that case, you could, right? Because that's supplementing the writing. That's not contradicting it. The writing was silent as to the color of the dry erase marker. It didn't say, it just said that we were going to deliver you one dry erase marker for $1, right? It made no mention of the color. So you could bring in a prior, if we found that it was partially integrated, you could bring in that prior statement to show, hey, look, this was supposed to be blue ink, because that doesn't contradict the writing, right? So that's kind of the difference between completely integrated and partially integrated. So the key to the Parol evidence rule is actually pretty simple, right? All you have to really do is determine whether you have a completely integrated writing, a partially integrated writing, or a completely unintegrated writing, and the conclusion will kind of write itself, right? Now, the only thing left will be look at exceptions, right? But basically, once you establish this, the rest of the analysis is pretty straightforward. So the question though is, how do you really make the distinction between a completely integrated writing and a partially integrated writing? We know how to distinguish between an integrated writing and an unintegrated writing. Remember, integration just means that the parties intended for this writing to be the final expression of the deal. Right? So if it's some sort of tentative draft, we know that's completely unintegrated. But if the parties intended for the writing to be the final expression of their agreement, how do we distinguish between complete integration and partial integration? Well, there's three different approaches here that you'll learn about in law school, but the best thing, right, and what you really want to, number one, always look for on a contract law fact pattern. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.